90% of junior lawyers make the exact same mistake when drafting a civil plaint. They write the evidence instead of just the facts. And guess what? The judge rejects it before the trial even begins. If you don't want your client's case thrown out under Order VII Rule 11, you need to stop using generic internet templates. In this masterclass, I'm giving you the exact 5-point formula to draft a legally airtight plaint like an absolute pro. Friends, I am incredibly happy to share that our channel has just crossed the 1 lakh subscriber milestone and we have officially received the YouTube Silver Creator Award. This achievement belongs to all of us, and I want to say a massive thank you for your continuous love and support. If you are new here and want to keep learning, please subscribe to the channel. It is completely free of cost. For those who wish to support our mission of spreading legal awareness further, you can now join as a channel member for just 59 rupees or 119 rupee per month by scanning the GPay QR code displayed right here on the screen. Thank you once again for your continued trust, belief, and support. Now, let us turn to today's important legal discussion. Part 1: Introduction and the Jurisprudential Purpose of a Plaint. Welcome to this comprehensive masterclass on civil drafting. Today, we are putting aside generic internet templates, bypassing shortcut forms, and diving deep into the single most critical document in a civil litigator's arsenal, the plaint. Whether you are a law student, a judicial service aspirant, an intern, or a junior advocate navigating the foundational years of civil litigation, your ability to draft an impeccable plaint will define your early career. A poorly drafted plaint is a structural disaster. It can lead to your case being dismissed at the very threshold, your client losing vital legal remedies, and your professional reputation taking a severe, irreversible hit before the trial even begins. In this session, we are going to break down the anatomy of a civil plaint from absolute scratch. We will dissect the statutory mandates of the Code of Civil Procedure, 1908, analyze critical judicial precedents, and walk through a precise, sentence-by-sentence structural analysis. Before picking up the pen or opening your word processor, you must grasp the fundamental philosophy of a plaint. Under civil jurisprudence, a plaint is not just a letter of complaint, it serves a crucial threefold purpose. First, it presents your client's case holistically. It is the official, definitive narrative of the dispute from the plaintiff's perspective, setting the ultimate boundaries of your litigation. Second, it explains the exact reason for approaching the court, establishing the judicial why by detailing exactly how the client's legal rights were violated. Third, it registers the matter within the court's official records, placing the dispute permanently onto the sovereign judicial grid. A point many young lawyers overlook is that your plaint permanently locks the legal battlefield in place. The court generally cannot look beyond what you explicitly plead. This concept ties directly into the doctrine of Secundum Allegata et Probata, meaning that a court can only decide a case based on what has been alleged and proved. If you fail to state a material fact in your plaint, you cannot suddenly introduce evidence for it during the trial stage. The opposite party will object instantly, and the judge will uphold that objection because the defendant was never given proper notice of that fact in the pleadings. Your plaint is your one opportunity to define the scope of the entire legal battle. Part 2: The core statutory pillars Order VI and Order VII of the CPC. Let's ground ourselves firmly in statutory law. A plaint is governed primarily by Order VI, which dictates pleadings generally, and Order VII, which deals specifically with plaints under the Code of Civil Procedure. If you open your bare act to Order VI, Rule 2 of the CPC, you will find the golden, foundational rule of all civil drafting. It can be broken down into 4 distinct, non-negotiable sub-rules that you must memorize. First, plead facts, not law. You must state the factual occurrences of your case, the dates, the events, the actions of the parties. You do not need to cite specific sections, acts, or case laws within the body of the plaint paragraphs. For example, if a partner in a firm misappropriates money, you describe the unauthorized withdrawal of funds. You do not write a paragraph explaining the definition of criminal breach of trust or citing the Partnership Act. The judge is presumed to know the law. Your job is to present the facts to which that law will apply. Second, plead material facts only. Material facts are those essential to proving your right to sue and establishing the definitive legal liability of the defendant. If a detail does not alter the legal outcome or the rights of the parties, it is immaterial. For instance, stating that the defendant arrived at your office in a red car to sign a contract is an immaterial fact. Stating that he signed the contract is the material fact. Keep your drafts lean, purposeful, and precise. Third, do not plead evidence. This is the most common error made by law students and young interns. You must state the material facts, known as facta probanda, but you must not state the evidence by which those facts are to be proved, known as facta probantia. For example, you must state that the defendant executed a promissory note on a specific date. You must not write about the specific witnesses who watched the signing, what color ink was used, or what those witnesses will say when they take the stand. Save that for the witness box during the trial stage. Fourth, your pleadings must be concise, clear, and cleanly divided into numbered paragraphs. Furthermore, all dates, sums, and numbers must be expressed in both figures and words to prevent any administrative ambiguity or typographical fraud. For example, always write, rupees 5 lakhs only, that is, 5 lakhs rupees. We are incredibly strict about these rules because of the sword of Damocles hanging over every civil suit, Order VII, Rule 11, which dictates the rejection of plaint. If your plaint fails to disclose a clear cause of action, if the suit appears from the statement to be barred by any law such as the Limitation Act, or if it is undervalued or insufficiently stamped and you fail to correct it within the time fixed by the court, the judge will reject your plaint at the threshold. To understand how dangerous this is, we must look at the jurisprudence surrounding Order VII, Rule 11. The Supreme Court of India, in the landmark judgment of Madanuri Sri Rama Chandra Murthy vs. K. Nagabhushanam, clearly established that when a court decides an application for the rejection of a plaint, it must look strictly at the text of the plaint and the documents annexed to it, and nothing else. The court cannot look at the defendant's defense, nor can it look at the written statement. The Supreme Court warned against what it termed clever drafting by advocates. Often, an advocate will craft a plaint so artistically that it creates an illusion of a cause of action where none exists, purely to bypass the limitation period or drag an innocent party into court. The judiciary has made it clear that a trial judge must read the plaint meaningfully and naturally. If a reading reveals that the suit is a sham or is legally barred, it must be terminated under Order VII, Rule 11 immediately. As a drafter, your writing must be so transparent, legally sound, and factually cohesive that it easily survives this strict judicial scrutiny. Part 3. The 5-point structural formula and document breakdown. To make drafting systematic, we utilize a structured 5-point formula. Every civil plaint, from a basic suit for money recovery to a complex intellectual property or property eviction dispute, follows this exact structural flow. Let's break down each element as if we were reviewing a physical document on our desks. Point 1. Court details and forum selection. The very first element at the absolute top center of your draft is the name of the court where the suit is to be filed. This requires a precise dual analysis of jurisdiction. You must establish territorial jurisdiction under sections 16 to 20 of the CPC. Let's look at how this functions by contrasting to different types of suits. If you are drafting a property eviction suit, Section 16 mandates that the suit must be filed exclusively where the immovable property is physically situated. It does not matter if the landlord lives in Delhi and the tenant signed the lease in Mumbai. If the property is in Pune, the court header must state Pune. Conversely, if you are drafting a money recovery suit based on a breach of contract, Section 20 dictates that you can file the suit where the defendant resides, carries on business, or where the cause of action arises, either wholly or in part. If the loan was disbursed in Pune and the agreement was executed there, that is where your cause of action arose, granting the Pune court's jurisdiction. Concurrently, you must determine pecuniary jurisdiction under Section 15 of the CPC, which dictates that every suit shall be instituted in the court of the lowest grade competent to try it. You must calculate the exact financial value of your claim and cross-reference it with your local state's Civil Courts Act and Suits Valuation Act. This determines whether your claim falls under the monetary threshold of a civil judge junior division, a civil judge senior division, or a district judge. A standard header will read, "In the Court of the Civil Judge, Senior Division, at Pune," followed by a blank space for the civil suit number and the year. Point 2. Party details and identification. Next comes the formal identification of the parties. Under Order VII, Rule 1, you must provide the name, description, and place of residence of both the plaintiff and the defendant. The format requires specific details arranged clearly: full name, son or daughter or wife of the respective parent or spouse, age, occupation, and complete residential address. If there are multiple plaintiffs or defendants, each must be numbered sequentially. Accurate, detailed addresses are vital because if a court summons cannot be served due to an incorrect or vague address, your case can face severe procedural delays or even dismissal under Order 9 for failure to serve cost or summons. Now, let's look at two critical legal exceptions that young drafters often overlook in the party details section. First, what if the plaintiff or the defendant is a minor or a person of unsound mind? Under Order 7, Rule 1, Subclause D, you are statutorily required to explicitly state this fact in the description. Furthermore, under Order XXXII of the CPC, a minor or an incapacitated person cannot sue or be sued directly. You must state that they are representing their interest or being sued through a designated next friend or a guardian ad litem. For example, your draft must read, ABC, minor, aged 14 years, minor through his natural guardian and next friend, XYZ. Failing to plead this proper representation renders the suit procedurally void. Second, let's address the real-world challenge where a defendant's address is genuinely unknown or the defendant is intentionally hiding to evade litigation. While the law mandates a proper address, if you have exhausted your search, you must state the last known address or place of business. If the summons cannot be served there, you do not lose your right to litigate. You can approach the court under Order VII, Rule 20 for substituted service. This allows you to serve notice by alternative means, such as physically pinning the summons to the courthouse door or publishing the entire notice in a widely circulated daily newspaper within the locality where the defendant was last known to reside. Once published, the law deems the service complete, and you can proceed with the trial. Regarding the inclusion of caste, in traditional, legacy templates used decades ago, you will often see a line for caste included in the description of the parties right under the father's name. In contemporary legal practice, the inclusion of caste is entirely obsolete, unnecessary, and discouraged unless a specific special statute, such as a matter under specific personal customary inheritance laws, tribal land protection acts, or agrarian tenancy acts, makes the party's caste or community status a material fact essential to establishing the legal standing, exemptions, or status of the suit. In all standard civil and commercial matters, omit this field entirely and stick strictly to clean identity, age, occupation, and residential descriptions. Point 3. The statement of facts. This is the core of your document. To draft this efficiently, we segment facts into two distinct categories: variable facts and fixed facts. Variable facts comprise the narrative unique to your individual client's case. Let's compare how the narrative structure completely shifts between two common civil disputes, a money recovery suit versus a property eviction suit. In a money recovery suit based on a breached loan agreement, your variable facts must lay out the story chronologically. Paragraph 1 establishes the business relationship, for instance, that the plaintiff is a registered merchant and the defendant is a long-standing wholesale customer. Paragraph 2 outlines the transaction, stating the exact date the defendant approached the plaintiff for a commercial loan, the specific amount requested, the agreed interest rate, and the mutually accepted timeline for repayment. Paragraph 3 details the documentation, stating that the defendant executed a formal loan agreement and a promissory note. Paragraph 4 details the breach, stating the exact date the repayment became due, how the defendant defaulted, and the subsequent return of a dishonored check. Now, look at how the variable facts completely change if you are drafting a property eviction suit. Here, your narrative does not care about financial loans or interest rates. Paragraph 1 must establish ownership, stating that the plaintiff is the absolute owner of the scheduled property. Paragraph 2 outlines the tenancy agreement, detailing the execution of the lease deed, the monthly rent amount, the security deposit, and the specific covenants regarding property maintenance. Paragraph 3 details the breach or expiration, stating that the tenant failed to pay rent for consecutive months or failed to vacate despite the lease expiring. Paragraph 4 details the illegal possession, stating that the tenant's occupation has become that of a trespasser after the lawful termination of the lease. Once your chronological narrative is complete, you must immediately transition into the fixed facts. These are the mandatory, jurisdictional boilerplates that must appear near the end of every civil plaint to satisfy statutory requirements. There are 5 critical fixed facts you must include. First is the pre-suit legal notice clause. You must state whether a formal demand or legal notice was served to the defendant, the date of service, the mode of dispatch, such as registered post AD or speed post, and the defendant's subsequent failure to comply. Second is the cause of action clause. You must explicitly state the exact dates and events when the cause of action arose. This is a mandatory requirement under Order VII, Rule 1(e). You must show a clear nexus between the dates of the initial transaction, the date of the default, and how the right to sue matured. For instance, you write that the cause of action arose on 12th January 2024, when the agreement was signed, and finally on 12th January 2025, when the defendant failed to repay the amount upon maturity. Third is the limitation clause. Under normal circumstances, Order VII, Rule 1(e) simply requires you to show that your suit is brought within the standard period prescribed by the Limitation Act, 1963. For a contract breach, this is 3 years from the date the cause of action accrued. However, you must be aware of an incredibly vital procedural rule under Order VII, Rule 6, which deals with exemptions from limitation. If you are filing your lawsuit after the standard 3-year limitation period has already expired, your plaint will be rejected on day 1 unless you explicitly plead a legal ground for exemption within the body of your text. For instance, if the 3 years passed, but the defendant wrote you a letter or an email acknowledging the debt on a certain date, that acknowledgement completely resets the limitation clock under Section 18 of the Limitation Act. Under Order VII, Rule 6, you must explicitly state, the plaintiff seeks exemption from the law of limitation under Section 18 of the Limitation Act, 1963, as the defendant gave a written acknowledgement of debt on a specific date. If you do not explicitly plead this exemption in the plaint, the judge has no power to grant it, and your case will be dismissed. Fourth is the jurisdictional assertion clause under Order VII, Rule 1(f). You must explicitly state the facts showing that the court has jurisdiction, for example, by stating that the contract was executed, the property is located, or the defendant resides within the territorial limits of the court. Fifth is the valuation and court fees clause under Order VII, Rule 1(i). You must state the exact value of the subject matter of the suit for the purposes of jurisdiction and court fees, and explicitly declare that the requisite court fee has been paid in accordance with the Local Court Fees Act. Point 4. The Relief and Prayer Clause. Point number 4 is the relief, commonly known as the prayer clause, governed by Order VII, Rule 7 of the CPC. The court will not grant a relief that you have not explicitly demanded. Your prayer must be precise, divided into clear subsections, and legally viable. You must state exactly what you expect from the court, leaving no room for ambiguity. For example, the plaintiff prays that this honorable court may be pleased to a. Pass a decree for the recovery of the principal sum, b. Award pendant light and future interest at a specific percentage from the date of filing until realization, and c. Award the costs of the suit. Always conclude your prayer with a final omnibus clause, which reads, pass any other or further reliefs that this honorable court may deem fit and proper in the interest of justice and equity. This grants the court the judicial flexibility to award auxiliary reliefs that flow naturally from your main pleadings but were not explicitly listed. Point 5. Signatures and verification. The final part of your plaint consists of the validation protocols. Under Order 6, Rule 14, every pleading must be signed by the party and their pleader or advocate. If the plaintiff is a corporate entity, it must be signed by a director or an authorized signatory backed by a formal board resolution. Furthermore, under Order VI, Rule 15, the plaint must contain a formal verification clause at the very foot of the document. The plaintiff must sign a declaration specifying, by reference to the numbered paragraphs of the plaint, what they verify of their own personal knowledge, and what they verify upon information received from legal counsel and believed to be true. This verification carries severe legal weight. Because it is a formal statement made under oath, any intentional falsification of a material fact within the verified paragraphs can invite criminal prosecution for perjury, presenting false statements before a court of law, and can lead to the immediate dismissal of your civil suit. Part 4. 3 Expert Pitfalls and Procedural Safeguards. To elevate your drafting from an amateur level to that of a seasoned trial lawyer, you must keep 3 critical, real-world procedural safeguards in mind. First, beware the trap of Order II, Rule 2 of the CPC, which deals with the splitting of claims. This rule mandates that every suit must include the whole of the claim which the plaintiff is entitled to make in respect of that specific cause of action. If you intentionally omit or relinquish any portion of your claim to fit into a lower court's pecuniary jurisdiction, or because you are in a rush, you are forever barred from filing a subsequent lawsuit for that omitted portion. For instance, if a tenant owes you rent for both the year 2024 and the year 2025, and you file a suit in 2026 claiming only the 2024 rent without obtaining explicit leave of the court to omit the rest, you forever lose your right to sue for the 2025 rent. You must think holistically and include all outstanding claims arising from that cause of action. Second, understand the strict mandate of Order VII, Rule 14 regarding the production of documents. A plaintiff must produce in court all documents upon which they rely or base their claim, and deliver copies along with the plaint. Many young advocates mistakenly think they can hold back their best documentary evidence to surprise the opponent during cross-examination. Do not do this. Under Order VII, Rule 14, Subrule 3, if you fail to produce a document at the time of presenting the plaint, that document shall not be received in evidence on your behalf at the hearing of the suit without the explicit, discretionary leave of the court. Obtaining that leave requires filing a separate application and showing exceptional, good cause to the judge. If the judge is not satisfied, your vital evidence will be shut out entirely, destroying your chances of winning. Third, ensure compliance with statutory pre-suit notices, particularly Section 80 of the CPC. If you are filing a civil suit against the government or a public officer in respect of any act purporting to be done by such public officer in their official capacity, Section 80 mandates a strict, prior written notice of 2 calendar months. Filing a plaint without serving this notice, or without obtaining special leave from the court to waive it in cases of urgent or immediate interim relief under Section 80, Subrule 2, will result in an immediate rejection or return of your plaint. Always audit who the defendant is before filing. Part 5. Career Blueprint and Conclusion. Before we conclude, a final administrative note for anyone preparing to present their first case in court: a plaint cannot walk into a registry completely on its own. When you assemble your physical filing packet, your plaint must be accompanied by several vital procedural attachments. These include the Vakalatnama, which is the document authorizing you as the advocate to act on the client's behalf, the formal list of documents filed under Order VII, Rule 14, a clear administrative index, a brief opening synopsis of the case, and the execution of a separate verification affidavit signed before an authorized notary or oath commissioner. Mastering civil drafting is your fastest, most definitive ticket to professional independence. When you join a law firm or intern with a senior advocate, you will not be handling high-stakes oral arguments in the High Court on day one. However, if your senior hands you a chaotic, unorganized file of client agreements, bank statements, and notices, and you return 24 hours later with a clean, structured, legally accurate civil plaint that strictly adheres to the mandates of the CPC, you instantly make yourself invaluable. You save your office hours of administrative correction, and that efficiency translates into professional trust and rapid career advancement. Drafting is not an innate talent, it is a precise, mechanical skill. It is a muscle developed through continuous, deliberate practice. Take hypothetical disputes, analyze real-world commercial contracts, study court registries, and practice building structured plaints using this 5-point formula. Thank you for dedicating your time to mastering the foundational craft of civil litigation. Keep learning, keep drafting, and continue sharpening your legal skills. If you found this information useful, please hit the like button, subscribe to the channel free of cost, and share your thoughts or questions in the comments below. For regular legal insights, don't forget to press the bell icon. I shall meet you again very soon in our next masterclass. Jai Hind! Jai Bharat!